Hi all, happy to meet you all after a long time. Today I thought of discussing Carlill versus Carbolic Smokeball Company Limited, which was a landmark case law in English contract law, which highlighted numerous factors and requirements in terms of offer and acceptance. So I thought of explaining this case law in order to conclude or in order to determine or in order to answer the question why the so-called companies doesn't ensure that their products, as they indicates in advertisements, are really standard and upholds quality 100%. They don't ensure the quality of their products in terms of their advertisements and commercials tallies the quality and the standard of those products 100%. They only say 99.9% that they could assure. What is the reason behind this? The reason need to be understood in the context of Carlill versus Carbolic Smokeball Company Limited case, which was heard in 1887. Let me first of all explain the facts of the case. Actually, this Carbolic Smokeball Company, they produced a medicinal product that they claimed would prevent users from contracting influenza. So those days influenza was a viral disease which was spreading so fast among the population in Britain. So this Carbolic Smokeball Company ensured if anyone uses this Carbolic Smokeball according to the instructions given in the particular medicine, the influenza would be completely cured. So they advertised that this in a newspaper. Also, moreover, they mentioned if anyone could prove this particular product did not cure the disease or influenza, they would compensate them by awarding £100. In order to demonstrate their sincerity, they also deposited £100. I apologize. £100 in a bank account in order to cover the potential claims. Mrs. Carlill purchased and used the smoke ball as directed, but still fell ill with influenza. So she sought to claim £100 reward, but the company refused. Company kept on arguing that advertisement was merely a mere puff and it doesn't amount to an offer. Therefore, it only amounts to an invitation to treat. In terms of the concepts of law of contract, they argued it doesn't anyway amounts to an offer. It's just an invitation to treat. In terms of this particular case, a legal issue arises. Whether this advertisement constituted a binding offer to the public that Mrs. Carlill could accept by performing the conditions set out in the advertisement. The judgment was given in this case, which was later considered as a landmark judgment in entire contract law area, where the Court of Appeal ruled in favor of Mrs. Carlill, and the lords who delivered these judgments moreover mentioned the key points. Let me explain one by one. As this is an advertisement which was made to the world at large, usually we believe in the context of contract law, advertisements are unilateral contract because it will be made to the world at large. So here the court recognized this to be an unilateral offer because it recognized where in this term, since this is an advertisement, that particular offer in the mode of advertisement have been made to the world at large, that could be accepted by anyone who perform the conditions specified in the advertisement. Also, the second key requirement would be acceptance by conduct. So Mrs. Carlill has used the smoke ball as directed, indicating that she accepted the unilateral offer which was established a binding contract. Also, court recognize another valid requirement which need to meet a valid offer to be born, that is intention to create legal relations. The court determined that the company had demonstrated an intention to be legally bound by their promise, particularly by depositing money in the bank. Also, Mrs. Carlill's use of the smoke ball was a sufficient consideration as she had acted upon the company's offer. As the court identified the valid requirements that need to be met in order to establish a binding offer has been existence in terms of this case. So the significance of this case would be, this case clarifies the nature of unilateral contracts and also acceptance, because it establishes that an offer may be made to the public and the acceptance can be through conduct rather than a formal agreement, as long as the terms of the offer are met. Additionally, it highlighted the importance of intention to create legal relations in commercial transactions. Therefore, this so-called case, Carlill versus Carbolic Smoke Ball Company, can be often cited in discussions about formation of the contracts, offers, acceptance, and the distinction between a valid offer and an invitation to treat. I hope this particular case note that I delivered today would make your day productive. Let me quickly see you with another fruitful video soon. Until that, stay tuned. Take care.